Welcome everyone to this Zoom seminar on New Dominion Constitutionalism and New Directions in Comparative Constitutional Research. My name is Christopher Roberts. I am an assistant professor here at the Chinese University of Hong Kong, and I will be chairing this event, which is co-sponsored by the Comparative Constitutional Law Forum and the Transnational Legal History Group under the auspices of the Chinese University of Hong Kong Center for Comparative and Transnational Law. We have many brilliant speakers today, and unfortunately, as is so often the case, time is limited. So I'll just give a very brief introduction and rundown of today's event, and then hand over the floor to the speakers. First up, Professor Thomas Poole, Professor of Law at the London School of Economics, will present on New Dominion Constitutionalism at the twilight of the British Empire. This presentation will also constitute an introduction to the collective research as a whole. Next, Professor Peter Oliver, Professor of Law at the University of Ottawa, will present the piece Dominion Status, History, Framework, and Context. Next, Professor Luke McDonough, Senior Lecturer in Law at City University of London, will present the piece Losing Ireland, Losing the Empire, Dominion Status and the Irish Constitutions of 1922 and 1937. Next, Professor Rohit Day, Associate Professor of History at Yale University, will present the piece Between Midnight and Republic, Theory and Practice of India's Dominion Status. Next, Professor Mara Malagodi, Assistant Professor of Law here at CUHK, will present Dominion Status and the Origins of Authoritarian Constitutionalism in Pakistan. Professor Rehan Abiratna will then, an Associate Professor of Law here at CUHK as well, will then present the piece Uncertain Sovereignty, Ceylon as a Dominion, 1948 to 1972. And finally, Professor Melissa Crouch, Associate Professor with the Law Faculty at the University of New South Wales in Sydney, will provide some reflections on the presentations and the project as a whole. Importantly, we will hopefully have around 20 minutes or so for your questions at the end. If you do have any questions, please use the chat function at the bottom of the Zoom screen to send those questions directly to me. I will collect them and will present the questions to the panelists during the question and answer session. For your information, let me note this event will also be recorded and shared on the center's website. So if you want to rewatch any of the presentations or to share the link with colleagues, it will, in short order, be available there as well. Okay, without further ado, allow me to hand over the floor to Professor Poole.
Thank you, Chris, and thanks so much to Mara and Rehan for organizing this event. It's lovely to be in Hong Kong this evening, albeit virtually, and to see you all, even though it's a distance. Now, it's a privilege to talk about our new symposium issue on New Dominion Constitutionalism. I, in fact, joined the editorial team rather late in proceedings. Mara and Luke had already put on a massively successful workshop at City Law School on the subject, where most of the papers that got into the symposium got their first outing. I was there at the event in the audience, both stimulated and very impressed. I'd just written a book looking at the British constitutional tradition over the longue durée through the lens of empire, but that book had little to say on the twilight of empire. The workshop, of course, focused exactly on that topic and raised some interesting and important questions, historical, legal, and political, that called for further exploration. So I was just absolutely delighted when Mara and Luke asked me to join the team. It was a pleasure to work with them, as it was with the other scholars we'll hear today. And it's just wonderful to see our joint enterprise come so successfully to fruition. I've been asked tonight to introduce the topic. The British Empire, being an ad hoc plural and many-faceted construction, inevitably much of the devil and indeed the interest lies in the detail. And for that, we'll have to turn to our case studies. But I'll say first just a little about what New Dominion Constitution is and where it fits, then indicate a few key findings that we drew from the case studies overall, before, if there's time, finally highlighting some of the broader themes to bear in mind when we go through the case studies this evening. So first off then, what is New Dominion Constitutionalism? Well, New Dominions is a term given to a subset of the new polities made independent from Britain right after the Second World War. Our study concentrates on three very major South Asian states that fall into this category: India, Pakistan, and Ceylon, later, of course, Sri Lanka, all becoming dominions in either 1947 or 48. Now, of course, these new dominions are part of a broader story of decolonization, and in particular, the dominion idea. For us, looking back in the 1920s, there was Ireland, which served as a template for these developments, hence our use of the term bridge dominion to describe it. And before that, what we call the old dominions, the white settler colonies, including Australia, Canada, New Zealand, South Africa, which achieved dominion status quite some time before and later went on to achieve full independence, of course. Now, they're part of that broader story. The new dominions represent a distinct and distinctive moment. Peter will talk much more to this, so I won't say very much, but the concept of dominion always treated on ambiguity. It suggested responsible government, delivered responsible government to some extent, but stopped perhaps short of full independence. And this ambiguity was maintained even through its codification, so to speak, in the Balfour Declaration of 1926, which studiously managed to avoid any talk of independence. Now compare the New Dominion constitutions. Again, here they retain much of that trademark ambiguity. In fact, it's an important feature, as we'll see in the stories. But the end point now, the trajectory, is much clearer. The former colony is unambiguously en route to full independence, though not necessarily immediate independence, albeit with continued external links to Britain. Also, the framers and drafters of these constitutions so rather desired. As such, New Dominion constitutions were actively designed to establish conditions for regime change within these newly independent states. Dominion constitutions served as both a provisional frame of government and the juridical basis for the subsequent independent constitution. So, in this role as juridical midwife for decolonization rather, New Dominion constitutions are both transnational and transitional phenomena. They remain, though, surprisingly understudied, particularly by lawyers. As a modality of decolonization by constitutional means, we hoped it would be of significant interest for constitutional scholars as well as historians interested in the period. That's the background then. What about our findings? What do we find? Now, of course, there's just oodles of local variation, and we're going to explore that in some detail in the course of today's session. But when we looked a little bit more closely, a basic structure did emerge. There's a consonance among these multifaceted instruments containing these fundamental elements. And we grouped these fundamental elements, we found 10 in the end, but we bundled them into three broad categories. The first being Westminster style of government, centered on a parliament, a strong central executive in cabinet form, but also containing an independent but relatively deferential judiciary. That's the first bundle. The second bundle speaks to the ongoing constitutional relation with the UK. There are a number of aspects here. The first being that, of course, these Dominion constitutions have their underlying authority sourced in an act of the Imperial Parliament, British Parliament. But second, that Parliament, the British Parliament, through the agency of the Statute of Westminster 1931, no longer had capacity to legislate for its former colony. Thirdly, the association or link with the Crown was maintained, a connection given concrete expression through the office of the Governor-General as head of state, appointed by the British monarch. That role was meant to be basically symbolic, but we'll see in both India and Pakistan, the Governor-General took on an active and quite controversial role. Finally, in this category, there was retained a right of appeal to the old imperial court, the Judicial Committee of the Privy Council, which produced some interesting jurisprudence, especially in relation to Ceylon. The third and final bundle of fundamental elements then, and these go to the transitional aspect of the model. The first and most obvious aspect, in a sense, is a negative, that is the lack of a clear roadmap towards full independent status. There's a vague or non-existent legal framework within these constitutions for drafting the permanent constitution. In effect, then, these instruments leave it up to diplomacy and compromise. And in practice, we find that this means giving lots of leeway to local political leaders and local elites. But secondly, in this bundle, we have the acquisition of new dominion status entailing a new international standing, meaning that the former colony could now be recognized as a full international legal agent and the bearer of corresponding rights and duties. So that's our basic structure that we might want to think about as we progress, the sort of essential elements or building blocks of this model. But what about some broader themes that we discovered in relation to the case studies? I've got a minute or two, I think, to sketch some of these broader themes, which we can carry with us into the subsequent analysis and discussion. First of all, I want us to focus on local politics and local perspectives. Of course, we're going to get chapter and verse on this very shortly in the case studies, but I want to flag up 3 quick points. First of all, I guess a question: why some nationalist elites were prepared to sign up to new dominion constitutional status in the first place? After all, they want independence, full independence, as quickly and as fully as possible, so to speak. In some cases, we'll see that it was, in a sense, the easier road to take. But by no means was it a universal choice. We see this in Burma at the same time. And also, it wasn't necessarily a no-brainer. The halfway house aspect, the ambiguity of new dominion constitutions worked to some extent against the designers in this regard, putting off, perhaps, or putting an argument against taking them on board at the local level. We'll see, and this is a prominent theme in all our studies, I think, that local elites took over pretty quickly, much quicker than metropolitan observers and designers would have thought. And partly as a consequence, we soon find out that metropolitan objectives were thwarted in all significant regards, I think. Third, there's the question of legacies, and this is something we thought about a lot, and it's very, very difficult for a whole bunch of reasons to pin down with great precision. But I think it's fair to say that these new dominion constitutions left a mark, even if it's often more of a shadow on subsequent constitutional developments within these states. Sometimes these are benign, sometimes malign, sometimes somewhere in between, but nonetheless, we can detect the shadow. The second broad theme is the British constitutional tradition. Obviously, that provides the basic structure for the new dominion constitutional model that I've just outlined. And metropolitan jurists and officials have become convinced over time, not only the superiority of that British model, which I guess you can call political constitutionalism with its hallmarks of pragmatism, useful ambiguity, the priority of politics over law, but all played out within a thin but robust rule of law structure. But not only were they convinced about the superiority of the model, they also became convinced that it could be exported to situations where it had not been, as it were, properly essayed before. 2 questions are derived from the experience in these new dominion constitutional situations. The first is about the viability or suitability of political constitutions of this sort in the absence of a shared constitutional tradition which animates them. And secondly, we're talking perhaps about political constitutionalism as refracted through the lens of colonial or imperial experience. In other words, we don't have necessarily a straightforward or pure copy of the British form, but one that has been tailored to or influenced by the pre-existing constitutions and government setups in these colonial and imperial settings. And the crucial feature at the institutional level is a heightened executive power and a weakened judicial power in these contexts, which I think in many contexts, as we'll see, proved really problematic. The final broad theme that I want to pick up, and to me, I think this is the most interesting one, relates to international politics, and perhaps the movement, you could say, from World War to Cold War. Note in this respect that New Dominion constitutions was a key part of the UK's international strategic imperatives and objectives. The timing here is not coincidental. Of course, the Second World War left the UK materially and politically, perhaps also morally weakened in a sense. And in these conditions, what it wanted to do was to facilitate independence, that was now going to happen for sure, while retaining strategic links. Now, initially, this could be made to match up, perhaps, if you squinted a bit, with a reconfigured vision of a global Anglosphere. In its first incarnation in the Victorian heyday of empire, this was about a global state, or perhaps a multinational commonwealth centered on Britain. In this second updated version, we have a reduced vision, but nonetheless a vision of a rule-based association of polities held together by informal ties of sentiment and self-interest, offering ideally stability and global leadership. Now, in reality, this of course became folded into, or let's be more blunt about it, superseded by Cold War politics. And above all, the narrative of the need to inculcate a now US-dominated Western sphere of influence. But in either of these global strategic forms, whether it's about the Anglosphere or about Cold War US-dominated imperatives, New Dominion Constitution, I think, was largely a failure. In particular, the associational ties desired by the form were severed. Alternatively, we might say that they never existed in the first place in any concrete way. But India in particular, for instance, turned its back on this for a time, on this Western sphere of influence idea. But with those three broad themes flagged and the model sketched, I'll leave it now to my colleagues to take the story on. Thank you.
Shall we go straight into to my 10 minutes? Okay, thanks very much to Mara and Rehan for organizing, and thanks, Tom, for that wonderful introduction. All sorts of things that I thought I should have said in my paper, you've just said. So that's great. When I wrote a book called The Constitution of Independence, really about the old dominions, Canada, Australia, and New Zealand, or three of the old dominions, I felt that I had to pitch the relevance of Commonwealth constitutional law and history to readers. That was because in the 60s, De Smith, Weir, Marshall, I mean, there were a lot of writers thinking about the topics that we're going to discuss today, but then it seemed to fade. Europe, at least where I was sitting in the UK, European issues took over. And that's why I felt I had to pitch the relevance. So it's really gratifying to seeing the resurgence of study in imperial and constitutional, comparative constitutional law. So my remit is dominion status, history, framework, and context. So I'm really going to focus on what do we mean by this word dominion. I was going to summarize what I was going to say, but I think I'll just launch straight in so that I have enough time. The first question I want to deal with is the ambiguity that Tom picked up on. you know, if I could give you just a crystal clear definition of dominion, I would. But in fact, Lord George in 1921, speaking for the House of Commons, this is quoted by K.C. Weir, when he asked the question, what does dominion status? He says, it's not the way of the British Constitution to provide precise definitions. It's this useful ambiguity that Tom's already alluded to. So just to give you an example of the usage over a 25-year period from 1900 to 1926, we're going to see 1926, the Imperial Conference is the moment that we're going to focus on, 26 to 31, the Statute of Westminster. But if we go back to around 1900, you can see in the royal titles the expression British dominions beyond the seas. And British dominions beyond the seas, dominions refers to everything, all the colonies. And so when the self-governing colonies wanted to distinguish themselves, they would add the modifier self-governing dominions. And so you can see that in 1907, the Colonial Conference, there's references to self-governing dominions. But after World War I, in both legislation and the constitutional conferences, the word dominion starts to include the modifier self-governing. So dominion becomes a way of distinguishing Australia, Canada, New Zealand, Newfoundland, South Africa, and Ireland. And so that's getting closer to the meaning of dominion that we want to look at. So essentially what I'm going to say is that to understand what the word dominion means for our purposes, we probably want to look, as I said, at this period 26 to 31. I'm going to come back to 26 to 31, but in the paper I wrote, I wanted to explore what I thought was a really interesting lead. And it's a reference by, and this relates to the general structure of the Empire and Commonwealth and what the dominions were trying to achieve in the Imperial Conference of 1926. And what W.P.M. Kennedy, who was an Irishman who emigrated to Canada and became a leading constitutionalist in Canada, and he was also an advisor to the Canadian representatives in the Imperial Conference. And what Kennedy said was that what the dominions were trying to achieve in 1926 was what the Americans had been trying to achieve in pre-1776. And so I'm just going to describe this in very broad terms, losing a lot of the subtlety of the intellectual history, which I wish I knew more about, but which I researched a little for the purposes of this paper. Basically, if you have a structure, I'm going to use my hands here, I should have a PowerPoint, but if you have a structure with the crown at the top, not because after the Glorious Revolution, the crown is genuinely at the top of the hierarchy, but for the purposes of the unity of the empire, the crown's at the top, and below it is the United Kingdom Parliament or Imperial Parliament, which I'm just going to refer to as the Westminster Parliament. But then below the Westminster Parliament, you have other elected institutions in the colonies, and the Americans feel, why is it that that our relationship is mediated through the United Kingdom Parliament? Why aren't we equal with the United Kingdom Parliament? Why is it that elected representatives in the UK are legislating for us? And of course, what was being legislated were taxes that were extremely unpopular. So what the Americans wanted was for the colonies to be equal to the United Kingdom Parliament underneath the crown. They would remain loyal to the crown in the empire as long as they could have that equality. And there are other things that eventually would follow from that, the conventions regarding who advises the crown. Does it always have to be the UK government, or if it has to do with local matters, shouldn't it be the local executive that's advising the crown? So that was the sort of structure that the Americans wanted. That was roundly refused, and they had to fight a revolution to gain their independence. And that idea gets packed away. But Kennedy says that it was explicitly recovered and pitched, and successfully pitched, because when you see the statement in the 1926 Imperial Conference. I'll just read the key statement known as the Balfour Declaration. It refers to autonomous communities within the British Empire, equal in status, in no way subordinate to one another in any aspect of their domestic or external affairs, though united by a common allegiance to the Crown and freely associated as members of the British Commonwealth. So you can see that the dominions in this case, the self-governing dominions, have come up level with the United Kingdom Parliament under the Crown. And that's, as I say, reminiscent of what was argued for by the Americans. So another way of coming at Dominion constitutionalism is to look at the certain markers which the 1926 to 1931 period tried to eliminate. I say 1926 to 1931 because some of the elimination was legally by the Statute of Westminster, but some of it was just by the emergence of new constitutional conventions, and some of those began immediately in 1926. So the just looking at my time. So these are fairly familiar markers. They're repugnancy, extraterritoriality, reservation, and disallowance. Repugnancy, this strange term, just refers to the fact that it was one of the markers of the empire that the legislation of the Imperial Parliament in Westminster had priority over the legislation of the even the self-governing legislatures. And that was put into legislative form in the Colonial Laws Validity Act of 1865. So regarding repugnancy, Section 2 of the Statute of Westminster said that henceforth the dominions could legislate inconsistently with imperial legislation, and that inconsistent legislation would prevail. A second marker was extraterritoriality. Prior to this period, if one of the self-governing dominions, or sorry, I won't call them that yet, but if one of the colonies legislated in a way that didn't relate to the geographical territory, their geographical territory, that would be invalid. The Statute of Westminster removed the bar on extraterritorial legislation. And I won't go into reservation and disallowance, but because I think that they're less important. One of the things I do want to emphasize is that the issue of sovereignty of Parliament is very important here, the sovereignty of the Westminster Parliament. And because of the way that Dicey and others conceived of sovereignty of Parliament, it was considered impossible for that Parliament to limit itself. And so you can see in Section 4 of the Statute of Westminster, there isn't a limitation on the United Kingdom Parliament so much as an attempt to say that legislation will not be deemed to have effect in the dominions unless it is the request and consent of the dominions is stated. The effect of that provision was extremely controversial going forward. Where I want to end is in relation to that sovereignty of Parliament point. Through the period that we're going to talk about, it was always considered unclear how it was that the Imperial Parliament could make a grant of independence. And so the course that was taken was this in-between status, which we call dominion status. By the 1960s and 70s, a lot of the uncertainties about sovereignty of Parliament had been worked through, and you can see that the independence is no longer granted in stages, it's granted immediately. The United Kingdom Parliament both validates an Independence Act and grants independence. So we might want to discuss the nature of this uncertainty in the period that we're going to cover now, and the reasons for the end of dominion status later on. Okay, I'll leave it at that.
Okay, I think it's me next. So thank you, Peter, for that introduction to Domain Status, and also to Tom for the wide-ranging issue introduction. Big thanks as well to Mara, Rayhan, Christopher, everybody at the Chinese University of Hong Kong for organizing this. So why is Ireland the bridge dominion in our study? That's the question that I'm interested in. And it is an important one because it links Ireland not just with the old dominions that Peter has discussed, so Canada, Australia, New Zealand, a little bit later South Africa, but also, more importantly, the enormous area in the Indian subcontinent that would come to be India, Pakistan, and Sri Lanka. Because the Irish agitation from the 19th century actually has two kind of streams, if you will. One is very much to keep Ireland within the United Kingdom of Britain and Ireland, but with a home rule parliament and fairer, better representation of the people within that parliament, and a large amount of sovereignty over domestic matters. But that tradition does not want to break away from the United Kingdom entirely. There's also then an anti-colonial tradition. And this is something that you don't really have to the same extent in the older dominions. They're looking for a form of self-government. There's nothing that you would really consider to be a national liberation movement. Whereas the kind of the Fenian tradition in Ireland that culminates in the 1916 Rising sees itself as an anti-colonial movement that wants to create an independent Ireland entirely free from the power of the imperial parliament at Westminster. And what we have by the early 1920s is that essentially both of these models have failed. The Home Rule model has run aground because in Northern Ireland there's a significant amount of unionists who do not want to break free from the United Kingdom and are willing to take up arms themselves, if necessary, to protect their status. And then you have the 1916 rebellion, which is stamped out pretty quickly by British forces. And so the idea that Ireland could militarily free itself from the British control simply ends. So instead what you have is a compromise, and that is framed by the Anglo-Irish Treaty of 1921. And what that treaty establishes is that there will be a new entity, which will be the Irish Free State. And that will comprise of 26 out of 32 counties in Ireland. That is essentially the present borders of what we now know as the Republic of Ireland. And it is kind of granted and agrees a new constitution for itself under that treaty. And this constitution is a very interesting document because it builds upon the Westminster tradition that Tom and Peter have mentioned. It includes several elements that are present in the Westminster Parliament, the two houses, the prime ministerial system, and so on. But it builds upon this in a way that hadn't yet happened, that the Irish example would be influential constitutionally to some of the later constitutions in the Indian subcontinent. So you have, for the first time in the 1922 Constitution, a Westminster model with constitutional rights review built in. So individual liberal rights to freedom of expression, to property, to liberty, and so on. And you also have something that was also relatively alien to the Westminster model at this point, though has become very controversial in recent years, which is referendums. So the Irish Constitution of 1922 says that amendments should require constitutional referendums, and you should ask the people when you want to change the document. But it also includes several elements that the more hardline Republicans within the Irish national movement object to. This is still, there is a new Irish Parliament of the Free State, but it is still, as Peter said, subservient to the Imperial Parliament of Westminster in a number of important ways. If you want to take up your seat in this Parliament from 1922 in Dublin, you have to swear an oath of allegiance to the King. The final court of appeal is the Judicial Council of the Privy so through the Judicial Committee of the Privy Council. And you also have the presence of the Governor General in Ireland, taking essentially the place of the king in kind of constitutional matters. And so you have attempts by the, it's a compromise document. So you have these innovative attempts by the Irish national constitutional writers to build upon the Westminster model with liberal rights review and so on. But you also have these badges of inferiority, which link the Irish Parliament very much to Westminster and mean that it is restricted in what it cannot do. So, for example, it cannot remove the oath to the king. It cannot remove the office of the Governor General. This is tied to the Anglo-Irish Treaty, and it's in the document itself. But as Peter says, things change in the early 1930s for two reasons. Number one is the Statute of Westminster, which, as Peter said, actually gives the Dominions the right to pass legislation governing their own territory. So it removes, in this clever legal way, the ability of the Westminster Parliament to directly legislate for matters relevant to the Irish Free State. And then you also have the rise in Ireland of a new political party, Fianna Fáil, and Eamon de Valera, who are a bit more hardline than the prior party, the precursors to today's Fine Gael. And they decide, well, we're going to legislate to remove the oath of allegiance to the king, the Governor General, and so on. But in doing so, they end up creating a lot of legal problems for the Irish Constitution of 1922. The most significant one is not an external problem. Westminster can't really do much at this point because of the Statute of Westminster. But internally, the Irish Constitution had been accepted by the Constituent Assembly, which was the Irish Parliament. And so the way that it was dismantled by Eamon de Valera and the Fianna Fáil party was very problematic in terms of the document's survival. And in the end, they decided that the way to resolve this was to create a new constitution in 1937. And this is the current constitution of Ireland today. It is essentially a republican document, though Ireland doesn't officially become a republic till 1949 when it leaves the Commonwealth. But essentially, it creates an independent 26-county Irish republic that has completely severed its ties with the Westminster Parliament. So how does this link then to the later dominions? In 1 minute, I'll give you a few points that I'm sure my colleagues Mara, Rehan, and Rohit will develop in their own presentations. In terms of Ceylon, there's an interesting dynamic going on in terms of the relationship between the Irish courts and the Judicial Committee of the Privy Council. Because Ceylon becomes a dominion for much longer than Ireland, this is much more developed in Ceylon, but it is there in the 20s and 30s in Ireland. And in the end, it doesn't really resolve itself because Ireland gets a new constitution so quickly, but that dynamic was developing. And it is interesting to see how in Ceylon that develops in an interesting way. The idea of Eamon de Valera that Ireland would have an external association with the Crown that would allow it to be a republic, but yet still remain within the kind of Commonwealth idea, was rejected at the time, but became the basis for India remaining in the Commonwealth, having become a republic with the new constitution in 1949-50. And so that was obviously highly influential on the Indian situation. As Rohit, I'm sure, will talk a little bit about and has talked about in his recent work and his recent book, the directive principles in the Irish Constitution of 1937 end up becoming influential on similar provisions in the Indian Constitution. And in terms of Mara's important work on executive power and constituent assemblies, we see that dynamic playing out in Ireland during the 1920s and 30s as well. But obviously in Ireland, we don't have Eamon de Valera or any other executive power in Ireland essentially carrying off a coup or terminating the democratic mandate of the state. But we have those tensions arising in a very important way. But obviously they're resolved, thankfully, not in the arena of military dictatorship or anything along those lines. So that's really all I have to say about Ireland. It contains some key elements that link it to the later dominions and some that link it to the older ones, which is why it is the bridge. So thank you for your time, and I'll hand over now to Rohit. who I think is going to talk about India.
Thanks. Thank you so much for having me at the workshop. So when Luke and Mara invited me to join their conference, almost 4 years ago, I said yes, mostly because I wanted a chance to talk with them and not because I was excited about India and dominion status. In fact, as I'll outline in the next few minutes, one of the big puzzles really in Indian constitutional law is the kind of hidden secret of dominion status. So as the sort of popular narrative goes, India turns independent at the stroke of the midnight hour. Nehru makes a famous speech. This speech gets immortalized in literature, in poetry. It gets a Grammy nomination in a kind of replaying. And it's really seen as a mark of break from the colonial period. Yet those of us who engage with constitutions know that it's really the Indian Constitution in 1950 that sets up a republic, puts into place representative government, and puts into place a Bill of Rights. So if you look at the sort of 3-year period where India is a dominion, it's sort of a puzzle why it isn't studied more extensively. In fact, the big question one might ask is what really changes? So while Nehru continues to be a premier in the interim government, as he was before independence, George VI continues to be Emperor of India, Lord Mountbatten serves as Governor General, a British Field Marshal leads the Indian Army, and judges appointed by the colonial government staff the high courts and the federal courts. The Privy Council remains on top. So in some ways, the dominion period remains a kind of awkward history. It's ignored by historians, it's forgotten in public memory, and actively neglected in official accounts. In fact, when the Republic is inaugurated, there are attempts to erase the connection with the dominion period altogether. So the Privy Council's jurisdiction is snapped off, and C. Rajagopalachari, who had served briefly as the first Indian Governor General, had his short term cut up abruptly, and he's not allowed to transition to the office of the President. In fact, the celebrations of independence, the sort of Congress Party's independence celebrations were on 26th of January, and this is sort of celebrated now as the new Republic Day. While work on Pakistan and Sri Lanka have shown how the dominion status lays the foundations for authoritarian constitutionalism in Pakistan and for the roots of ethnic conflict in Sri Lanka, the scholarship in India seems to imply that dominion status had little or no impact over the constitutional future. Part of this is the sort of lengthy Congress Party's continuity over the period. So they were in power in 1947, heading the Dominion, and this power is reconfirmed through elections in 1952. So there's a kind of popular legitimacy given retrospectively to the actions of the government between those 4 years. However, for those of us who are lawyers and more attuned to the importance of legal structures, the absence of interest in the impact of dominion status poses the kind of puzzle that I want to talk about. So does dominion status matter? If so, how does it matter? Why does no one want to talk about it? And this ties into questions of constitutional choices and as well as constitutional path dependency. So to resolve this, what I do in the paper, and I'll briefly talk about here, is really to turn to 2 questions. One of historical causation. So why did Britain offer and India accept dominion status? It's sort of seen as an inevitable transitional approach. But if we look at this, we see that the Indian independence leaders from the late 1920s had rejected the possibility of dominion status and demanded complete independence. Nehru in particular had protested a kind of early resolution of dominion status by saying the idea of a dominion suffocates and strangles him. Beyond sort of instrumentally accepting dominion status, the paper will argue that there are strategic reasons for accepting it, which is the interest of the Congress Party in having a government that is flexible, centralized, and in some ways authoritarian for this period of transition. Secondly, if dominion period was always supposed to have a short shelf life, I mean, by 1947, everyone knew that a Republican constitution was on its way. Why did the British government agree to it? They had pushed against the dominion for a really long period of time. And once they knew it was going to exist for a fairly short period, what factors led to it being accepted? And I want to explain this really through the idea of temporality and break it into 3 categories. So the category of dominion itself is bounded by a notion of time. There's a sort of idea of dominions as juvenile members in the international community, a kind of rite of passage before full adulthood. And this marks a shift from a system of empires which have divisible sovereignty, where imperial rulers can hold together a variety of variegated legal spaces, to the international order where you have to have a more homogeneous division of sovereignty. So the dominion status sort of invokes the idea that India, not giving India dominion status, invoked the idea that India was even less than juvenile and became a source of mobilization by Indian nationalists. Conversely, it threatened white dominions who feared a loss of privilege that came with the status if India is sort of brought into the club. The second idea of time is really that of speed. So the process through which dominion status is granted, namely an act of parliament in London, is tied to a certain determinable speed. And this is contrasted by the sort of long structures of constitution making and party negotiations that we see happening in various parts of the British Empire. Finally, constitutions themselves mark the beginning of a new order, signaling a break from the past. So the short period of dominion status in India establishes the legal infrastructural base of the Indian Republic. India integrates over 500 different sovereign territories into the new state. It removes jurisdiction of Privy Council. It fights a war in Pakistan. It suppresses numerous armed revolts and quashes internal dissent through inherited colonial security apparatus, alongside drafting the country's republic constitution. And it does so in this sort of gray zone between the colony and the republic. So the question of dominion status really comes up with the Treaty of Versailles, where there's India is a signatory to the treaty and occupies a sort of strange position between dominions and colonies. And in the words of one of the colonial officials, India is less than South Africa and Canada, but higher than New Zealand, Newfoundland, and the other colonies like Kenya or the Strait Settlements. And through the 1920s, dominion is always offered to the Indian nationalists as a promise that's about to come. But this is only until the Statute of Westminster comes into place in 1931. And we see sort of anxious correspondence within the colonial government. So Samuel Hoare, for example, says the question of dominion status has changed with the Statute of Westminster. Hoare says, the term dominion status was acceptable as long as it was a status, because it's fluid and the ultimate interpretation of powers remains in London. But the Statute of Westminster clearly defines powers for dominions. Can one actually say that India will function exactly like the functions claimed under the Statute of Westminster? So this shift from status to constitutional function makes the British government more reluctant to offer it as dominion. So through the 1920s, we see constant sort of reiteration of Parliament that dominion status will be eventually provided. But by the 1930s, it seems to disappear from the scene. In the words of the Secretary of State of India, dominion status works as long as it is a mystic word, but the moment we give it legal instantiation, this becomes a problem. Very similarly, the Indian nationalists also seem to discover this around the same time. So through the 1920s, a variety of nationalists from Gandhi to Motilal Nehru argue that dominion status is merely a framework to give themselves self-government within the British Empire. And they don't care what the wording is, as long as the result is that they get self-government. But by 1929, the new leadership of the Congress and increasing radical politics argue that essentially until India, it's impossible that India would become an equal member to the British Commonwealth, and unless the continuing system of exploitation of races is discarded. One of the things that we don't talk about extensively is that from the 1920s, the variety of white dominions had been raising objections to not just migration from India, but also sort of equality of India within imperial institutions. So, for example, an attempt to have a sort of peripatetic Privy Council with judges from all the colonies gets shot down by objections raised by Australia and South Africa. So I'm not going to go into extensive details about why the Indian side agreed to dominion status or why the British side agreed, except to highlight 3 points. For the British government in 1946, while they were aware that dominion status would be fairly short-lived, they believed it was essential to preserve sort of British military interests in Asia during the beginning of the Cold War. And they understood that being a member of the Commonwealth, in the absence of the Indian nationalists agreeing to a defense pact or a defense treaty, membership of the Commonwealth at least allow for a common defense plan. Anita Inder Singh discusses it fairly extensively. The second is that the idea that, and I'm going to be very quick. The second is the idea that dominion status is a very well thought out policy is rejected by the fact that the revelation of papers show that the decision to leave, especially with impending partition violence, was one taken in haste. And Mountbatten changes the date of independence, and they want a quick device to allow them to transfer responsibility and power. So dominion status allows for that speed of transfer of power without necessarily going into sort of long-term questions about constitutional features and strategies. On the Indian side, part of it was that the Congress government understood the need to have a strong viceregal state to bring in the kind of transformation in society and economy that were needed at a time of crisis, a country recovering from famine and a sort of violence of partition. And through this period of 3 years, we see sort of debates in various places about how colonial practices of government continue. And the Congress government keeps arguing that the problem is not with the practice itself. The problem was that the colonial government put it to sort of bad ends, as opposed to the Congress government, which is using it for national interest. The second, and I'll end, is the role of dominion status in allowing for the Indian government to acquire the territories that existed in the princely states. So India consists of over 500 princely states, which were in a variety of treaties with the crown. And from the 20s, the states argued that these treaties were in nature of a contract and could not be assigned away to an agent, which is the new Indian government. But from the early 40s, both the British government and the Indian nationalists argued that by assuming the functions of a dominion, the Indian nationalist government could take over the functions of advising the crown with respect to the various princely states. And while several princely states, particularly Hyderabad, tried to claim dominion status for itself, this option was sort of closed out. In the paper, I also look at what the kind of legacy of dominion status is in India today when judicial interpretation comes in, but maybe I'll talk about it in the Q&A. Thank you so much.
Thanks so much, Rohit. I'm going to pick up the bat of the South Asian dominions from you. And let me just see. So what I wanted to talk about today is and the origins of authoritarian constitutionalism in Pakistan. And I guess really what I wanted to do was to engage with the question that Tom asked at the end of his presentation. What's the mark, what's the shadow that dominion status left on the jurisdictions that we studied? So I'm going to try to do that with respect to Pakistan. So first of all, if we look at the context here, and what we have in the period of dominion status, what we have, and that's a difference from India, we have actually a much longer period that we're considering here. Okay, so we're looking at a period of transitional politics. So we're looking at independence from August 1947 as a union until 1956, in which Pakistan actually a republic, exactly the same way as India in 1950, with the promulgation of the new permanent constitution. What do we know about this period? For the newly created state of Pakistan, a state that was territorially divided between the western wing and the eastern wing after the bloodshed of partition, we're looking at an incredibly difficult time that revolves around state building between two territorially discontinuous parts of the state. After a war with India in 1948, in a very difficult and weaker economic military position compared to the bigger neighbor. And also we see a very polarized socio-political context with different cleavages moving along the political spectrum, ethnic affiliation, language affiliations, and so on. What's interesting about Pakistan, in my view, as a case study, is that the constitutional arena becomes the primary battleground for political engagement during these early years of independence. And also, going back to another point that Tom raised with regard to the framework paper, is that, of course, it's a critical time politically from the point of view of international politics with the Cold War heating up in Asia. So what we know is that Pakistan is the only South Asian country that aligns itself very clearly with the Western Bloc, and in 1954 joined SEATO, the Asian equivalent of NATO. So when we look at the Pakistan's dominion constitution, what do we have? We have the exact same starting point as India. So we have the Government of India Act 1935, which was effectively the constitutional framework under which British India was ruled for a number of years before independence, but amended by the Indian Independence Act 1947. And we have two main functions that this constitutional text is there to provide. First of all, to offer the legal basis for the conduct of government during the Dominion transition period. And secondly, the Dominion Constitution forms the basis for drafting the permanent constitution. Exactly like in India, it creates a constituent assembly that is also to function as parliament. It is indirectly elected, but doesn't really tell us very much about which direction constitution building for the new independent country has to go. So it doesn't provide much of a roadmap. So if we look at this constitutional mold that we consider here, what are the key features that we want to bear in mind? First of all, we talked about that, I think, in each one of the presentations so far, that we're looking at a highly flexible constitutional framework in line with the British tradition, which means that a lot of key political, operations of the constitution itself are really left to the working of constitutional conventions. But of course, constitutional conventions are a form of customary law that has developed in the English context over centuries. So one of the questions, of course, is to what extent can they be transplanted? To what extent can they travel well in a post-colonial context? In terms of continuity, the head of state remains the Queen, but the power is actually exercised by the Governor General of Pakistan. We have a cabinet government, which is responsible to the Constituent Assembly / Parliament, and that's one of the differences. So if the model is the same one of the British tradition, what you see in terms of differences is that the legislative link that we had between the Imperial Parliament and Dominion Parliament actually is severed. And that's the purpose of the Indian Independence Act amending the original Government of India Act. Also, as Rohit mentioned, the jurisdictional judicial committee of the Privy Council is retained at the moment in which the Dominion Constitution is granted from London, but the link is eventually rescinded in 1950, the year after the Indian government did so. So what do we have here? When we think about this period, my paper focuses particularly on one instance, which is the dissolution by the Governor General of the first Constituent Assembly by a use of royal prerogative power, essentially. An area which actually is not specified, a power which is not spelled out under the Dominion Constitution. So it's actually the litigation really brings to light the way in which constitutional conventions have been interpreted in the Dominion context. But of course, you know, the dissolution of the first Constituent Assembly happens in October 1954, so well into the Dominion period. Actually, and if you look at the paper, I don't really have the time to go over that now. If you look at the history of since the creation of Pakistan as a Dominion, you actually have quite a progressive, ever increasingly egregious set of violations of constitutional conventions that would have been a part of ordinary political praxis in the UK context. So you have almost a build-up to that eating away at substantive constitutional guarantees and rules of political conduct that you would have in the UK context. So what's the background and what's the issue with the work of the Constituent Assembly is also acting as parliament? So by September 1954, the Constituent Assembly is basically done with the drafting of the permanent constitution. The problem is that the draft that they had prepared is not really in line with the main political forces that now control the Pakistani state. And that's what's being defined as the military bureaucratic axis, so the non-elected part of government spearheaded by the Governor General. So those effectively in control of the executive are not very happy with this draft constitution that is about to become the permanent constitution of Pakistan for a number of reasons. So at this point, the Governor General intervenes, and in effectively what is a coup d'etat, dissolves the first Constituent Assembly / legislature. But then, of course, the action politically is very clear that it's a coup d'etat effectively, but the constitution is not clear about what the powers are under the document. So the president of the Constituent Assembly files a case a judicial review case, essentially asking the High Court of Sind to reinstate the assembly. They're successful at first instance, so that kind of confirms the substantive idea that New Dominion constitutionalism, alongside, you know, the Indian experience, is really a halfway house that effectively the country is independent. Of course, the government appeals to the highest court of the land in Pakistan and wins. So effectively, the federal court changes it, essentially, you know, decides differently from the High Court, and confirms the worst fears of all nationalists, that Dominion constitutionalism really was not the high road to independence. So what you see in the case, and you look at the arguments and all of that being made in court, if you look at the judgment, it's really interesting to see the kind of argument put forward, but effectively that's a legitimation in legal terms of a political coup. So there is a lot of historical details in the paper, so if you want to go back to that, it offers a lot of colorful spy stories, like looking at the government, the lawyers involved, and all of that. But I wanted to reflect very briefly, we conclude with 3 points about what the Pakistani case study offers in terms of this broader model that we elaborated on New Dominion constitutionalism. So first of all, what you see in the functioning of New Dominion constitutionalism, it's a subversion of key substantive tenets of the Westminster constitutional model due to political expediency. So effectively, what you have is a procedural approach in which only the simulacrum of the constitution is left. It becomes a hollow vessel. To put it in the words of Oko Thogendo, it's a constitution without constitutionalism. What you have, which is significant on the part already of the first Constituent Assembly, is to move away from the British model already during the Dominion period. So you have attempts to introduce greater powers for the courts as a counter-majoritarian checks. That's generally one of the, I think that's one of the biggest takeaway from the Pakistani case study. And also an attempt to let key rules of political conduct not regulated by conventions put them on statutory grounds. And these two elements actually are reflected in the drafting of the permanent document. So there was an awareness in Pakistan of the inner dangers of the flexibility of the Dominion constitution. And I think that's the biggest takeaway, and that's the shadow that Dominion constitutionalism really left in the Pakistani context. I hand over to Rehan.
Okay, well, thank you all for joining us from various locations and time zones. Thank you to Chris for chairing. Let me also thank Bonnie Lung and our IT team for excellent admin support. So my paper is called Uncertain Sovereignty, Ceylon as a Dominion, 1948 to 1972. Let me just say a few background things about this case study and about Ceylon, which is now known as Sri Lanka, as Tom mentioned earlier. And then I'll get into the kind of meat of the paper. So I think Ceylon is a really interesting case study because in some ways it's a middle ground between the old or settler dominions of Canada, Australia, New Zealand, and what one Sri Lankan prime minister called the tropical dominions of India and Pakistan. Regionally, obviously, it's in South Asia. There are similarities to the other states in the Indian subcontinent. But culturally, at least at the elite level, Sri Lanka is more Anglophile. And I'll explain in a minute how this played out in terms of the negotiations towards Dominion status and then the Dominion period itself. But in short, it was a mixed blessing, right? So on the one hand, there's no bloodshed, there's no partition. But on the other hand, there's no serious engagement with the underlying ethnic divisions, which would rear their ugly heads quite soon. And there was no real engagement either about what self-government would look like. Again, as I'll explain in a couple of minutes. Eventually, Sri Lanka got Dominion status, what was called somewhat confusingly fully responsible status, because it was thought that dominion status would anger certain elements of the population. They finally got it in 1948, and they had it until 1972. So 24 years of dominion status, which is far longer than its neighbors. And as a result, I think we can sort of see the shadow, as Tom put it, of that period much more clearly in some ways in the subsequent history of Sri Lankan constitutionalism. So very quickly about the Dominion Constitution, it's widely known as the Soulbury Constitution because Lord Soulbury had a commission which sort of looked into the matter and then drafted a constitution. And despite this commission apparently looking into the facts on the ground in Sri Lanka, what they effectively did was just to take the Westminster system and adapt it slightly, and then just kind of transplant it to Colombo. Sir Ivor Jennings was the driving intellectual force. My colleagues here know much more about him than I do. Certainly I know Mara does. It's worth noting, though, that Jennings was the vice chancellor of the University of Ceylon for many years. He knew the country reasonably well. He wrote one of the first textbooks on the Constitution of Ceylon, and had a very close relationship with Ceylon's first prime minister, D.S. Senanayake, which led him to be in the room, as it were, to draft the Soulbury Constitution. As a result, the Dominion Constitution has very few entrenched rights. Jennings famously, as Mara has written about, disliked what he called the Indian style of entrenched rights. And so there's actually only one rights provision in the Dominion Constitution, and it's in section 29(2). And it says in relatively general language that the Ceylon Parliament shall pass no law that discriminates against any religious group or community. The only other aspect that's, I think, relevant for my purposes today is this manner and form limitation that Jennings placed on the Ceylon Parliament, right? So Jennings, unlike Dicey, who I think Peter was talking about earlier, believed that Parliament in the UK could be restricted by so-called manner and form limitations. And so he kind of applied that logic here. And so while the Ceylon Parliament wasn't prohibited from doing anything, except for discriminating against religious groups or communities, it was required to have a 2/3 majority to amend the Constitution. And as I'll explain in a minute, this becomes relevant in a couple of cases, right? Everything else, as in the British Constitution, was left to convention. And if you know anything about the political history of Sri Lanka and the constitutional history of Sri Lanka, that was not a good idea, right? It didn't work out well at all. So very briefly, how things unfolded. The first prime minister, as I mentioned, D.S. Senanayake, had a good working relationship with British elites, was able to negotiate dominion status fairly effectively. He also, to his credit, was not an ethno-nationalist, which is a rare thing among Sri Lankan politicians, especially these days. And as a result, his death in 1952 is widely seen as a turning point in Sri Lankan constitutional history. Thereafter, there was a rise of ethno-nationalism. Politicians like SWRD Bandaranayake played to the sort of insecurities, I would say, of the Sinhalese Buddhist majority, who had felt slighted for various reasons under British rule and kind of wanted to assert themselves. And as a result, there was a kind of unraveling of the shared Ceylonese identity. There was a 25-year civil war later on. And of course, there was the end of dominion status in 1972. I'm sorry I'm painting with such a broad brush, but I suppose that's the way it has to be under these sort of tight time limits. So in the paper, I try to take a sort of legal approach to this. As Rohit mentioned, I think correctly, partly because Sri Lanka had a long dominion period, there's actually quite a lot that's been written about that period and quite a lot that's been written about, in various ways, the way the Constitution affected the politics of the time and vice versa. So I try to actually look a little bit more at the judiciary and at a couple of cases dealing with both fundamental rights and structure, and try to see the degree to which sovereignty-based concerns and uncertainty around sovereignty really drove some of the judicial decision-making. So in the fundamental rights realm, what I found was that both the Ceylon Supreme Court, which is the highest court for Ceylon, and the Judicial Committee of the Privy Council, which was the court of final appeal, the court of final adjudication, I should say, for many colonies, including Ceylon, were unduly deferential to the Ceylonese parliament. A notable case was the Kodeshwaran case in 1967, which challenged the constitutionality of the Sinhala Only Act. This was an act that mandated that Sinhala, which was the majority language, would be the only official language of Ceylon, which, at least in my view, is a prima facie violation of Section 29(2) of the Solberry Constitution, because it discriminates against non-Sinhalese speakers, notably the Tamil and Muslim minority groups in Ceylon. The plaintiff in this case was a Tamil clerk who refused to sit a Sinhala proficiency exam to get a promotion in the civil service. Case gets to the Supreme Court, which avoids the constitutional issue altogether. It simply notes, after a very perfunctory comparative analysis, that the Indian and American Supreme Courts are reluctant to decide constitutional questions, and therefore it should do the same. The Privy Council then upheld this judgment, again, without much discussion. Right? And I think this is a good example of the kind of undue deference that was given to the Ceylonese parliament. I argue that's because there was some confusion whether the Ceylonese parliament was actually sovereign in some sense, since it kind of copied the Westminster model, but in fact it wasn't, right? It not only was it a creation of Westminster, but there were these limitations that I mentioned before, both Section 29(2) and then the manner and form limitation on constitutional amendments. On sovereignty, a similar story emerges. On constitutional structure, a similar story emerges. Here, the only difference was, while the Supreme Court of Ceylon remained quite deferential, the Privy Council was actually quite activist in some senses. Many of the cases in this era involved the Ceylon Parliament's power to create tribunals that would exercise something akin to judicial power, right? And so there were questions raised, such as whether the Parliament had the power to do this, whether it had to amend the Constitution to do this, and whether there were any substantive limits on its amendment powers. The most famous of these cases is Bribery Commissioner versus Ranasinghe, which I think is kind of a widely known case, even outside Ceylon. This is a case in which, involving the Bribery Act, which the Ceylon Parliament had passed, that created tribunals to try and convict government officials and some others accused of bribery and corruption. The controversy, though, was that the Bribery Act seemed to give these tribunals something like judicial power, but Parliament had not amended the Constitution to do this. Right? So the Supreme Court, as I mentioned, was deferential, it upheld the act, but the Privy Council reversed. And Lord Pearce's opinion has now become quite famous. The beginning of it is actually, I think, fairly straightforward and correct. He basically says that there's a plain conflict between the Bribery Act and the provision of the Solberry Constitution, which vested judicial power in the courts. He also was careful to say that the Privy Council was only enforcing a manner and form limitation on the Ceylon Parliament, and said explicitly no question of sovereignty arises here, right? So he was aware of the concerns that may arise domestically if he intervened too strongly, and so he was very clear about what he was doing. And he said, look, we're holding this law unconstitutional, we're not allowing this law, we're striking it down, but Parliament could pass it as a constitutional amendment if it had a 2/3 majority. Then Lord Pearce goes wrong, and he goes wrong with this infamous dictum where he basically says the following. He's referring to Section 29(2), the provision that prohibits religious and communal discrimination, and he says, these provisions further entrench religious and racial matters, which shall not be the subject of legislation. They represent the solemn balance of rights between the citizens of Ceylon, the fundamental conditions on which inter se, they accepted the Constitution, and these are therefore unalterable under the Constitution. Okay? And it's that last part that I've italicized that became really problematic. This was used by nationalist politicians to actually end dominion status, right? So Ranasinghe and Lord Pearce's opinion was perceived, and it was sold to the public as a foreign intrusion on Ceylonese sovereignty. I think, again, this conflates the country's sovereignty with parliamentary sovereignty. All Ranasinghe said was that Parliament was bound by manner and form limitations, but Lord Pearce's language said that they were unalterable, right? Which suggests that there was a substantive limit on what Parliament can do. On an interesting and random side note, this language was picked up by Chief Justice Sikri and a few of the other justices in the Keshavananda opinion in the Indian Supreme Court, which famously declared a basic structure doctrine. And my former colleague at the General Global Law School, Shiv Prasad Swaminathan, has actually written about how this misunderstanding of the Ceylonese Dominion Constitution then led to the basic structure doctrine, which has then led to all kinds of other things, both in India and elsewhere. Okay, and just to conclude very quickly, subsequent Sri Lankan constitutions, I think unsurprisingly, their two republican constitutions, have severely limited the scope of judicial review. And I think Lord Pearce has something to do with this. I think this is to some degree a reaction to what they saw as an overzealous Privy Council. And generally, I argue in the paper that I think this sort of general misunderstanding or uncertainty about sovereignty had lingering negative effects on Sri Lankan constitutionalism. The Sri Lankan judiciary has never developed sort of structural independence the way, say, the Indian Supreme Court did. It's arguable whether the Indian Supreme Court maintains that, but at least for a while, I think it did. And I think, as I said earlier, I think the length of the Dominion period in Ceylon had a lot to do with this, right? So I think the sort of the longer period under this kind of odd transitional arrangement lengthened the shadow that would be cast over Sri Lankan constitutionalism subsequently. So I'll end there. Thank you all again for attending, and I'll hand over to Melissa. Thanks again.
Thanks, Rehan. And I want to begin by saying congratulations to the editors and authors of this volume. I really enjoyed reading it. I loved it, and I personally do think it is probably the best special issue ICON has ever published. But what I'm going to do is kind of zoom right out. And in the brief time that I have, I want to say something about the field of comparative constitutional law. So this special issue, I think, is a promising glimpse of what the field of comparative constitutional law could look like. The new directions it could go in, the new spaces that are opened up by experiences of constitutionalism from the Global South. In many ways, I think the Global South is sometimes perceived to be at the margins of comparative constitutional law, something of the lesser known intellectual peripheries. And yet I think it has so much potential to offer new sources of understanding. And here I do consider Ireland perhaps as what anthropologists John and Jean Komaroff might call the South in the North. So this special issue on Dominion constitutionalism, I think, shifts the conversation. So often we talk about the Global South simply in relation to activist courts. So we move away from that, and instead the authors take us to constitution making from the Global South. Or more to the point, they focus on this interaction, if you like, between Global North and Global South at the end of colonial rule. So I want to suggest that this volume provides us with 4 alternative understandings about the field. So the first is that it offers an alternative understanding of key concepts in comparative constitutional law. Here I'm particularly thinking of the idea of interim or transitional constitutions. And I think it very much shows that our current or conception of interim constitutions is revealed as narrow and short-sighted, and that the horizon of transitional constitutions is much longer than we thought. Second, I think the volume offers a alternative history of constitutionalism. So it asks us to think about when, how, and why Dominion constitutions emerged, and to what effect. And this focus on legal history, I think, is a correction to the presentism of much scholarship on comparative constitutional law. It exposes the limits of our current thinking on transitional or interim constitutions, and I guess grapples with the tensions inherent in this idea of Dominion constitutions. A kind of imposed but not yet imposed transitional constitutional arrangement, something of a halfway house or a grey zone, as Rohit has described. Very much a contradiction, not quite colonial rule, but not yet fully independent. Third, I think the editors and authors ultimately contribute to building alternative narratives of the field of comparative constitutional law that includes and embraces the Global South and is very much conscious, I guess, of the ways interactions between Global North and Global South shape our very ideas and conceptions of constitutionalism and constitution making. And then fourth, and perhaps more provocatively, I think this special issue shows us that the field of comparative constitutional law, which very often has claims of universalism, is in fact based on a kind of Euro-American or Northern view of things. And so it got me thinking about, well, why is it that the field of comparative constitutional law has, in some sense, forgotten about Dominion constitutions? Is this intentional? Does it say something about the legacy that they've left? Why is it that this is kind of a gap in our understanding of constitution making histories? And I think this collection of articles on constitution making at the end of colonial rule or the start of post-colonial rule, depending on how you look at it, is particularly salient in 2020, a year when questions about the legacy of colonial rule and how we remember it are very much front and center of global public attention. So just to conclude, where do we go from here? What do we write next? I think there are lots of opportunities. One is, of course, to expand geographically. The editors, I think, point out that Africa, the Caribbean, the Oceanic Islands, that there are possibilities, I guess, to try to identify broader patterns in experiences of Dominion constitutions by going beyond South Asia. But more broadly, I think I'd be keen to see a conceptual piece that thinks about reviewing the literature on transitional or interim constitutions to incorporate what we now understand and know from this volume on Dominion constitutions. So that is, how do we now think about transition constitutions differently because of this volume? And then just more broadly, I do want to say that I'm very much a fan of special issues, whether it's books or journal articles, where they're done well and where they bring together a group of scholars to, in many ways, kind of begin forming a new scholarly community and new kinds of inquiries. And I think that sometimes that's the only way that work that is perhaps perceived to be marginal ever becomes of interest to a broader audience. So I'd very much encourage the panelists, as well as those listening today who have interests in this area, to continue these discussions and conversations. And I look forward to seeing where these ideas take us next. Thanks.
Okay, thank you so much for that fantastic commentary, Melissa, and thanks to all the panelists for all of those amazing presentations. As so often happens with so many speakers, you know, each one of whom I think actually quite tightly controlled themselves, that there was clearly so much more to hear from everyone. But as it is, we've run very short on time. What I propose perhaps is that, begging the indulgence of the speakers, if it's okay with them, perhaps we run a little bit over time in order to have a little bit of back and forth question and answer session. I see mostly nods. Of course, the speakers are free to turn off their cameras and run away if they have to. So please, everyone, if you do have any questions, please feel free to send those to me in the chat. And I'll just take the chair's prerogative, I suppose, to start off the questions. I think I largely got a sense that I already have an answer to this one, but just to ask it more directly, I wonder how the speakers would answer the question of whether or not the existence of these temporary transitional new Dominion orders led to more or less rights respecting states in the short term and in the long run, if anyone has any thoughts about that.
So, I mean, I'm just speculating, but I think, at least from reading our papers, what seems to come through is not the formula of dominion status itself, but how it works as a kind of memory for future regimes, or what it does for creating a certain kind of infrastructure. So my takeaway from Rehan's, in a way, Rehan's paper contrasts really interestingly with the Indian case, because in some ways, dominion status was seen as an example of what would happen when there were entrenched rights and an activist judiciary, and works as a kind of subversive model for ethno-nationalist politics in Sri Lanka. Whereas in India, during this period, there's a wide range of governments curbing rights. But in the early 50s, the judiciary sort of uses the fact that there's a new constitution, and the new constitution marks a break from dominion time to sort of suggest that we can have judicial review of a range of things, including in the early years, sedition and things like that get struck down. So I think more than the device itself, it's also about the particular kind of history in each space and the kind of memory that it carries into the future.
Can I have a go at that? I mean, that's such a brutal question to throw at us at this time of the night. I mean, it's immensely hard for a whole bunch of reasons. I mean, there's so many examples, so many different trajectories here, enormous bunch of counterfactuals. You're an evil man. You're an evil man. In a sense, I'll sort of, try to hone down your question a bit, because you said, rights respecting states was the adjective, I think. And I just wonder whether it's worth thinking about this whole enterprise, of sort of interactive state building and constitution making, in terms of a series of gambles. It's a shot in the dark, or a bunch of shots in the dark, and in a certain sense, the choice is how to err. You're probably going to fail, unless you're extremely cocky. You're probably going to fail. These are immensely complicated polities. They're not even polities in many senses, but it's very, very difficult, very immensely difficult enterprises, and some of that has come out in today's summaries. But there's more of that, much more of that detail in the papers. They're brilliant on that, and I can say that because I didn't write one of the case studies, so it's all my wonderful colleagues here who did. But I suspect if you're sort of standing back and thinking about these in terms of how they're gambling, how they're choosing to fail, I think they're saying, okay, what we ideally want is, if we're going to fail, let's fail in terms of, liberties and rights. We can sort of, we can hope for more, but we can fail. We can sort of, we can fail on that front to some extent. As long as we win when it comes to questions of violence, political violence, stability, and so on, we need to get these things up and running. And I think to some extent, that's a shared sentiment to a degree, perhaps from different angles, both from the UK, the metropolitan centre, and from at least some of the local elites. That there's both, framing decisions and choices, but also choices at the local level by politicians, officials, and judges, even courts, that err on the side of authority rather than liberty in the end. And I think there's, as I said, I think that's partly how things are set up for a bunch of reasons that we've already talked about, but also because that's also the way, to some extent, that the UK Constitution deals in a funny way with rights, at the time at least. They're in a certain sense fundamental, but they're also sort of peripheral. They're worked into the warp and woof of constitutions in a sort of political, unstructured, ambiguous, and amorphous way. They're everywhere but nowhere, in a sense. So that's my attempt at trying to respond to a brutally hard question. So thanks for that.
If I can just add one thing to what Tom's eloquently said, which is that there's obviously an external and an internal dynamic at play here. And as Tom outlined in the first introduction to this session, the British are primarily trying to keep all of these kind of restive countries within their sphere of influence. And the Westminster model and dominion status is a way of doing that. And there are states at the time like Burma that just say, F off, we're not getting involved in this at all, and they just go immediately to independence without without passing go and collecting $200 or whatever the monopoly position is. But you do have as well a lot of what are the important rights and who are the powerful people and who are the majority and who are the minority. That dynamic is playing out in a very powerful way internally. And it's interesting that both in Sri Lanka and in Ireland, the British are, the only right that they're really concerned about in Sri Lanka that they kind of impose as part of the constitution is about minority rights. And in Ireland, there's certainly a dynamic of wanting to make sure that the Protestant minority in the Free State are not taken advantage of or kind of rooted out of the place. There wasn't really a great danger of that happening, really, given that there were lots of kind of Anglican Protestants who were like Yeats and people like that who were very prominent and who were very much believers in kind of the nationalist cause. But the British were certainly, to some extent, concerned about that. But for them, it was mainly about power. I'm not sure the British cared that much about creating rights-based states that would be respecting of individual rights. What they wanted was to try to keep these states within their sphere of influence. And as Tom outlined in his introduction, that slips away very quickly. In different ways, these states go their own way. And even the one Ceylon, where they keep the role for about 30 years. When it slips away, it's just completely gone, and the Privy Council decision becomes the basis for the country going in a different direction.
Perhaps I could just throw one thing in. I was just trying to find in my bookcase. I think it's a book by Parkinson from about 12 years ago. It's OUP, and it's about rights well, I think it's the position of the Foreign Commonwealth Office on rights, to the extent that the Foreign Commonwealth Office or British cabinet and executive is driving things. Their view was not to include rights in any of these constitutions until, I think he says, the mid-50s, when there's actually a big flip, and then rights form part of the, we'd be going into the African, not exclusively, but a large number of African constitutions then do include rights. So that would be a source. I read it, but a number of years ago, but I don't recall enough to relay it. But I commend the book to you.
Oops, speaking with mute on. Thank you all so much for those fantastic answers. I would love to keep following up. Thanks, everyone. We have more questions coming in, but conscious of everybody's time and the fact that we've already run over. I think what remains for me is to thank all of our fantastic speakers today on behalf of everyone. I'm sure muted as they are, they can't express their appreciation directly, but I'm sure they all join me in expressing their appreciation to all of you for this fantastic event. And of course, they know they can go and look at that special issue of ICON to find out more.